Hey everyone, my name is Altagracia Pierre Outerbridge. I am a landlord tenant and immigration attorney in New York City. My firm is Outerbridge Law PC. We are located in Midtown Manhattan. Our phone number is 212-364-5612. I wanted to take some time today to talk to folks still in the How Do I Break My Lease series about domestic violence as it relates to landlord-tenant. So this is particularly relevant now as folks have heard, there has been a report of a spike in the number, right, of domestic violence cases during this confinement period. So I wanted to let folks know that, number one, my heart goes out to you in this difficult situation. And number two, there is actually a method in the law for tenants to deal with domestic violence and break their lease without liability. So that law, that statute is RPL, Real Property Law 227C, and that statute provides for the actual procedure, and it's a rather procedural statute. It provides for the actual procedure for breaking your lease based on being a victim of domestic violence. So with your permission, as I speak to you today, I want to make sure that I'm hitting all the points in the statute, so I will be looking at my notes at different points. So first, RPL 227C asks for you to provide a notice, right? A qualified statement to the landlord. So what is a qualified statement? A qualified statement, as it's defined in the statute, is a sworn statement saying containing very specific information. Notably that you are a victim of domestic violence and that you feel that residing in the apartment with your abuser, right? It has to contain an effective date of termination, which can be no less than 30 days from the date of the notice, right? And if you're mailing it by regular mail, which it can be, you have to give it an extra 5 days. So really 35 days by mail. It has to be delivered in that manner to the landlord and to your co-tenants, but it does not have to be delivered to your abuser, right? So next steps, within 25 days of your delivery of this notice to the landlord, so you have some time, you would provide the proof that you were indeed a victim of domestic violence, and that the statute provides for what documents would qualify to support the fact that you were a victim of domestic violence. So of course, one of the obvious documents that you can provide is an order of protection, temporary or permanent. You can also provide a statement by a healthcare provider, a treating physician, a therapist, a psychiatrist, a psychologist to whom you have reported domestic violence, your situation of domestic violence to. A police report detailing domestic violence is also a good document. So you only have to provide one of these, not all of them, right? And the law provides that should you follow this procedure, that your lease would be deemed terminated within 30 days, right, of that the first notice, and that your rent would be prorated to the date, the actual date, the effective date of termination that you have stated in your notice. So to recap, there is a method for victims of domestic violence to vacate and not suffer, right? Not suffer in silence, not remain and be in harm's way during this period of confinement. So my name is Outerbridge Law PC. That's it for today. My firm is Outerbridge Law PC. My name is Altagracia Pierre Outerbridge. Our number at Outerbridge Law PC is 212-364-5612. And that's it for today. Talk to you soon. Bye.